Hello folks, welcome to Legacy IS Academy. In this video, we will be discussing a current affair topic presented to you by your faculty, Sushma KP. So what is the topic that we will be discussing today? Babri Masjid remark and the curative petition debate surrounding it. So let me start it up like a story. Recently, Justice D.Y. Chandrachud had in an interview held that erection of Babri Masjid in the first place was an act of desecration. Desecration means, let's assume a structure is there, you destroy that structure and build something on top of it. Understanding? Here, Babri Masjid, it was held that, okay, look at the words I'm using, it was held that Ayodhya ka Ram Janmbhoomi, whatever was there, was desecrated, and on top of that, Babri Masjid was built. Understand? This was one of the, uh, let's say, a section of belief of the people. Alright? Now, what happened just at this statement, that is, whatever Justice D.Y. Chandrachud held in the interview, Professor Mohan Gopal, when he was in Calcutta attending a seminar, he said that this statement alone hints at opening the doors for curative petition. Now, what is a curative petition? Will it mean again your Ayodhya verdict can be resurfacing? First of all, for that, let's take up your Ayodhya verdict of 2019. It was a 5-judge constitutional bench where one of the judges was your Justice D.Y. Chandrachud. Understanding? Wherein the verdict told that temple construction at Ram Janmbhoomi can be started and a 5 acres of land to be given to Sunni Waqf Board. This they have highlighted in a 1045-page judgment. Why it was this long? Because it was 30,000 plus pages of records. Understanding? Now what happened was, while your let's say before Ayodhya verdict could be reached, the avenues for, that is, many avenues for mediation was attempted even before the final verdict was to be given. Understanding? Despite that, a mediation could not be reached. Now the question will come to why. See, Ram Janmbhoomi, that is your Ayodhya issue, is not something that started in the recent times. It's been a long-standing conflict. One of the reasons why they could not reach at a mediation was because it was not binding. Public itself was not ready to take into consideration, and this is not just a matter of just one or two people, but it involves a lot of things with regard to religious sentiments, people's beliefs, and also how the people are taking it up. Understanding? At this point of time, judiciary made sure it will keep all the doors open, it will create mediation chambers, and it said that it even created let's say parties in order to make sure that a mediation could be reached. Both sides were heard very well. Understanding? Listen to these points, further you will understand why I'm explaining these points. Both sides were heard, both sides were given for mediation, so much so up until the final verdict, but it could not be reached. It has a lot of say in the public eye also, the public opinions, the public binding, everything was involved here. So your judiciary decided, okay, now we cannot treat this in the conventional cases where we have to go for invocation of Article 142, which is complete justice. Your Article 142 invocation itself means that by conventional manner you cannot treat this case. You need to go a step above and make sure all the natural justice elements are imbibed in. That is called as complete justice of Article 142. Now, Justice Chandrachud remarked stating that erection of Babri Masjid was a desecration, that is breaking down of a previous temple. Okay, your Professor Mohan Gopal has held that 2019 judgment is not speaking in these lines. They have not taken into consideration of any conclusive proof of a temple being destroyed and its material being used to build Babur's Masjid. So this has sparked a lot of legal and political actions. As to first and foremost, the debate is the Professor Mohan Gopal has held that this itself, the remark from Justice D.Y. Chandrachud itself, will open doors for curative petition. The question is, what is this curative petition? This is one of a very rare and very minimally used concept. Understanding? It was originated in your Rupa Ashok Hurra versus Ashok Hurra case, wherein, if at all there is a concept of natural justice violated and one of the party is not heard, or if there is a judicial bias of one of the judges being present is not disclosed, that is what they are claiming for your Justice G.Y. Chandrachud remarks. Understanding? Then this will leave open for a remedy, that is your curative petition. This is only a last resort, very rarely used and very minimally imposed. Okay, this can either be filed before the same or larger bench. Now the question is there actually room for curative petition in Ayodhya case? According to Madan Gopal's view, this remark of Justice D.Y. Chandrachud was inconsistent with the judgment. This could possibly be curative, that is, there could be a possible bias, is what he is telling. But what is the actual condition? Were all the parties heard? Yes, all the parties were heard. Was mediation explored? Yes, so much so up until even the final verdict was reached, mediation was considered. Was there judicial bias proven? No such as of now. One more reason your judges are claiming is, do not just read parts of the judgment, read the complete judgment. It is 1045 pages. So if someone has the patience time, read the entire judgment, then talk about the judgment. Understanding? They have given a reasoning and also a comprehensive reason as to why they have did what they have did. So the concept of a curative petition based on just this statement alone is very unlikely to be succeeding. So, what are the legal principles involved? Let's say in your Ayodhya case itself, first is Article 142 was used, wherein Supreme Court used complete justice, and this is beyond the statutes and your normal law and order implementation. Second is they made a Ayodhya case, they made a reference to your Union Carbide case. Then they held that equity and public policy are to be considered, and they have gone beyond and above to even suggest remedies. Understanding? So, this verdict is a mixture of law, history, constitutional morality, and it attempts at dealing with the age old conflict. Now, if you see, Justice D.Y. Chandrachud remarks, yes, it has opened old debates, but just for this sake alone, a curative petition to be started, this does not have any valid legal backing for this. If at all anything, Ayodhya judgment proves the Supreme Court as a guardian of law, equity, harmony, and the upholder of the Constitution with regard to following it. Understanding? So when we say yes, they are truly, let's say, guardians of fundamental rights, they are guarding it. Understanding? With this, we come to the end of the content. If you like our content, subscribe to our channel, hit the like button, share it along with your friends. Thank you.